about a Supreme Court ruling that came in just a couple of hours ago today. It relates to people, their families, the doctors looking after them as well, people who are in a persistent vegetative state, sometimes known as minimally conscious. There are obviously, clinical sort of gradations to the state that somebody is in. But it's an interesting, stark ruling, really, by the Supreme Court today. Legal permission, until that ruling, legal permission by the Court of Protection was required for a decision to be made to withdraw nutrition and hydration from a person in that state. And individuals there was the fairly recent case of Paul Briggs, the Merseyside police officer, whose wife and family campaigned for that right to be given to them. That they could withdraw nutrition and hydration because after an accident he had been left in a state of minimal consciousness and was not expected to come out of it. So an active young man, a father, a husband, police officer, was to just be no more, have no more to do in this world. And that was the decision that they wanted and ultimately got after taking it to the Court of Protection. Today's decision by the Supreme Court takes the Court of Protection out of the picture if the family and the doctors agree that nutrition and hydration should be removed. So agree that a patient should be allowed to die, left to die, depending on how you see the scenario. So it's going to be easier to withdraw food and liquid from patients like this, to allow them to die across the UK, not just a decision that affects England, but across the UK. Is that something that we should uniformly welcome? Or is it something, particularly in light of the recent report into the Gosport Hospital Trust, where the Reverend Bishop James Jones said there was, in a report that he carried out, that there was a culture of shortening life, big investigations into what went on there, into one doctor in particular, but not only, the Liverpool Care Pathway, which was the approach that was taken and approved in England and Wales, the Care Pathway approved for how we ended a person's life when they were on the palliative care pathway or similar. There were huge problems discovered with that, and that was got rid of. So we've got fairly recent examples of rights being given to medics and family around these issues being abused, haven't we? We've got fairly recent examples of those rights being abused. We have plenty of examples of them being used well, but being abused as well. So is this something that we should welcome? Less involvement by the courts in decisions around the ending of someone's life. 0345 606 0973, the number is the number you can call. You can text, as usual, on 84850 or tweet at LBC. Dr. Anthony McCarthy joins me, board member of the organisation called Care Not Killing, and Rabbi Dr. Jonathan Romain, chair of the Clergy Group for Dying in Dignity. Good afternoon to both of you.
Good afternoon. Hello, Sheila.
Dr. Anthony McCarthy, first of all, your response when you heard that this is the decision that the Supreme Court had taken?
Well, I think it's a rather shocking and decision. I think it goes with a certain trend and a way of thinking about these issues, which is unfortunate and removes a further protection in the lives of people in very vulnerable states. So I think it's based on bad medicine, and I think it ultimately is a further rung in the devaluation of human life.
Why do you say it's based on bad medicine, particularly?
Well, the category that we're talking about, we've seen the Court of Protection has actually overturned in a number of cases proposals to remove food and fluids from people who have subsequently actually recovered from those states and become aware and conscious. Now, these are not a huge number, but when we're talking about minimally conscious states, there's a lot of things that are unknown about those states. And as I say, there are cases where people recover from those states. Now, that's obviously not going to happen if food and fluids are deliberately removed, where people are starved and dehydrated to death because of that removal, not because of the underlying condition that they're in, but simply because somebody else has chosen to remove food and fluids, which we all need to live, because a judgment very often will have been made that such lives are not worth living.
So you seem to be hinting that, in many cases, from your perspective, it's the pressure and stress on the healthy relative that's taken into account rather than the individual who's lying in the bed.
Well, I'm saying that the whole idea of a court of protection is to protect the genuine best interests of somebody in that state, and protection will be needed in many cases, human beings being what they are. That there will be pressures and things that come into play in a doctor's or considerations or a relative's considerations when it comes to actually valuing the life of a person in a certain situation. The court of protection was there to ensure that the value of that life was very seriously taken into consideration. Now, this judgment has started to talk of best interests as though there is the best interest served by starving and dehydrating someone to death.
Let me bring in Rabbi Dr. Jonathan Romain to this. I know that you don't share the same exact same concerns as Dr. Anthony McCarthy. Do you think this is inherently a positive move?
Help for those people facing the enormous emotional trauma of having a loved one who is in this persistent vegetative state. Now, let's be very clear. It's not saying, this judgment is not saying that they should die. It's still going to have to be the agreed verdict of both the family and the doctors and the medical staff, and that's why it's very different from the Gosport Hospital Trust, where some of the medical staff acted by themselves and without consulting the family. So it's going to have to be a joint decision, and it can only happen if both family and the medical staff agree. And the difference is that previously, until now, it was a very cumbersome, very expensive legal process to go to the Court of Protection, whereas now they can do it if those two parties agree, and it's on certain grounds. For instance, there is no hope of recovery, or, for instance, the person had previously stated, if I'm ever in a vegetative state, then please let me die rather than keep on. So the key is still the interest of the patient, not the convenience of anybody else. And if there is a disagreement, either by the family or by the medical staff, then there's still the right to take it to the Court of Protection if no agreement can be made.
What about Sorry, go on, Anthony.
Well, that's no real protection at all. I mean, all you need then is for a family, say, who perhaps, are looking forward to a will or for reasons that they regard another person as very burdensome. All you need for them is to agree with a doctor that the best interest of somebody else is that they no longer cease to exist and are literally starved and dehydrated to death by the removal of food and fluids. You're saying, well, the best interests are served because an agreement has been made. I would say that nobody's best interests are served by that.
Who's to say that the judge has any better idea of what is right?
Well, the judges have overturned a number of...
Anthony, hang on. Don't shout over the guest. Go on. Carry on.
Yes, why should the judge have a better idea than A, the family who knows the person, or B, the doctors who have the proper medical insight? And remember, we're talking about people who are in a sort of living death situation. They've got no engagement with anybody around them. They don't respond. They can't communicate. They've got no awareness of what's going on. So it's not as if you're killing off somebody who is sort of got the potential of having a good life, like somebody who may be in a wheelchair or whatever.
Well, I'm afraid you.
All right, go on, Dr. Anthony McCarthy.
You may be rather ill informed. A number of people have recovered from this state. Minimally conscious state includes awareness in its own definition. You talked about living death. These are living human beings who are awake in many cases and aware of certain things, some of whom have come through this. They have a value, despite the fact that you're treating them as though they are dead. They have a value and they deserve protection. And you are proposing that food and fluids be removed, someone be, in many cases, deliberately starved to death, simply because other people have deemed that their life no longer has value. I'm saying that a human being, insofar as the human being is alive, has a value and we have certain obligations and duties towards them.
Final thought,
actually,
Rabbi
I'm
Dr.
not
Jonathan Romain.
proposing it. This is actually the Supreme Court that has delivered a very considered judgment. And number two, persistent vegetative state actually precludes awareness and responsiveness. If someone is able to respond either with their eyes or a fingertip or a toe or whatever, they knew they are not in this condition. So actually, what you said may be true about other people, but doesn't apply to this particular group.
But minimally conscious people, like Paul Briggs, for example, a decision to allow his nutrition and water to be withdrawn was taken. So it can be taken in minimally conscious scenarios.
It can be, but again, only as a family, and by and large, most family are pretty loving and want the best interest of the patient. And if the doctors have any idea that they're acting for mercenary reasons, then they will oppose it. And of course, this all goes back, if you remember, to the tragic case of Tony Bland?
Tony Bland,
That's right, who was one of the
victim,
victims, who was in a permanent vegetative state in 1989, and the courts were not sure what to do, which is why this whole idea was invented of a court of protection, which that actually did allow him to die 4 years later in 1993.
That's right. Thank you very much indeed. I was going to mention his case, but you've done it for me. Thank you, Rabbi Dr. Jonathan Romain, Chair of the Clergy Group for Dying in Dignity, and many thanks as well to Dr. Anthony McCarthy, Board Member of Care Not Killing.